Good morning, good afternoon, and good evening to all the participants, distinguished members and our guest faculty for the session today. I, Rahul Kumar, am your host for the session today and welcome all of you on behalf of Nivaaran, Mediators of Supreme Court of India, to this ninth session of the 4th International Virtual Summer School on Mediation, which has been jointly organized by CLA in collaboration with Commonwealth Lawyers Association and Singapore International Mediation Center. We have with us today Dr. Fan Yang, Director of International Dispute Resolution Academy, and Mr. Robert Gerrad, Senior NEC Consultant and Secretary NEC Users Group. In today's session, we would be hearing insights from Dr. Fan Yang on the very important Singapore Convention on International Settlement Agreements resulting from mediation, vis-a-vis scope of application and future of mediation. Mr. Gerrad would be enlightening us on yet very important topic of our commercial practice, which is on application of mediation skills in construction industry, vis-a-vis introduction to NEC contracts and mediation skills for a NEC project manager. After we are done with the presentation, the participants are free to ask their questions either through the chat box or by raising their hands. Without further ado, I would like to introduce Dr. Fan Yang, who is a CEDR and HKMAAL, which is Hong Kong Mediation Accreditation Association Limited, accredited mediator. She is on the panel of arbitrators and mediators of the Kuala Lumpur region, Center for Arbitration, and a listed arbitration of the Hong Kong International Arbitration Center. She is a fellow and an approved faculty member of the Chartered Institute of Arbitrators and a past committee member and vice chair of the China Committee, the CIR East Asia branch. She is a fellow of the International Academy of the Belt and Road and a member of the working group on dispute resolution for the Belt and Road. She has published widely in a range of leading journals, including the International and Comparative Law Quarterly, Cambridge University Press, and Arbitration International, Oxford University Press. More recently, she co-authored Contract Law in Hong Kong, a comparative analysis, which has been published by the Hong Kong University Press. Dr. Fan Yang has comparatively extensive experience as an arbitrator, and she has arbitrated in English and Chinese languages. She has been appointed as an arbitrator under the ICC Rules of Arbitration and HKIAC administered arbitration rules, and has extensive experience in arbitrations under other leading institutional rules, as well as in ad hoc arbitrations in leading institutional seats, including London, Hong Kong, and Stockholm. We are pleased to have you today with us, Dr. Fan, and I request you to take the floor and enlighten us on the topic today. Dr. Fan, over to you.
Okay, so sorry, I'm just looking for how to unmute myself. Thank you so much. It's such a great pleasure and it's an absolute honor to be here to join you tonight. I would like to thank Santhan, Rajiv, and Rahul, and for all the hard work in putting this program together, and also for having me as one of the faculty members tonight. I have given some thoughts on the topic. Given the time constraint, I'm only going to touch upon two topics tonight under the Convention on International Settlement Agreements resulting from mediation, the Singapore Convention. The first part of my presentation will look into the scope of application, and then the second part of my presentation, we will look into the future of mediation. Again, in the context of the Singapore Convention, questions will be, does the Singapore Convention really share lights to where the future of mediation is? So going into the first topic, the scope of application, I have in front of me the convention. And I think that most of you, if not all of you, would be well aware of this database or this website that's set up for the Singapore Convention. So if you tap in, Singapore Convention, you'll find it. So it's the official website. And then on that website, you'll find all the resources available for this convention. So including the text of the convention itself. So if we're looking at the scope of application, well, I probably would need to quickly explain why. Why am I looking at the scope of application? I suppose it's the first article, it's Article 1. So naturally, we start with the first article. But I think more importantly, for practitioners, for mediators, for lawyers in particular, we want to, understand, we want to make sure that we only apply the convention when it's clearly applicable. I'm not sure how many of you are aware of other conventions such as the CISG, for example, and the convention that you can opt in. So I suppose the first question that I would invite you to consider is whether the parties can actually opt in the convention if they want to. Yeah. So let's say we have two Indian companies, maybe because of the shareholders, they have international foreign shareholders, but they are incorporated in India. So they are two Indian companies, and they are, involved in a contract that's probably performed in India alone. So if there is no other international elements, can they opt in? Can they say, well, nevertheless, we want to apply the Singapore Convention? So I think these are the, one of the questions that would relate to the topic of the scope of application. So if I could, invite you to have a look at Article 1 of the Singapore Convention, and it says, this convention applies to an agreement resulting from mediation and concluded in writing by parties to resolve a commercial dispute, which at the time of its conclusion is international. And then it defines what international means in the context of this convention. And similar to other conventions like the one that I mentioned, and also I think even the New York Convention, they have this very similar, I think probably the same definition of international. So at least two parties to the settlement agreement have their places of business. So we're looking at the places of business in different states, which means it doesn't matter, if the shareholders are foreign or international or not. All that matters for the purpose of this article is the places of business. So two Indian companies, the places of business are in India, then sorry, you won't fit in this Article 1(1)(a). How about B? The state in which the parties to the settlement agreement have their places of business is different from either the state in which a substantial part of the obligations under the settlement agreement is performed, or the state with which the subject matter of the settlement agreement is most closely connected. So now we are looking for different states. Yeah, one is the states in which they, the settlement agreement, parties to the settlement agreement have their places of business. So let's say both parties, their business, the places of business, both are in India, but this time the state in which the substantial part of the obligation. So for example, if two Indian companies, they invest in another country, let's say country B, and that settlement agreement is to do with, or the settlement agreement will be performed, substantial part of that settlement agreement will be performed outside of India, then again, this mediation Singapore Convention may apply. And the other one is or, right, different from, so the state with which the subject matter of the settlement agreement is most closely connected. So in that case, maybe the subject matter, I don't know, maybe a construction project, and this construction project is closely connected to a different country, then again, it's possible for this Singapore Convention to apply. So I think that if we're simply saying, oh, you have to be parties where their place of business are in different states. That's only the first link, the 11A. But don't forget, we also have 11B, and underneath 11B, we also have 2 scenarios. So in other words, when there is an international element that fit in 11B, then the mediation settlement agreement, the mediation Singapore Convention may apply. Then we look further, the second paragraph of this, so Article 1, 2 and 1, 3, those 2 deal with the exclusion. So they explicitly exclude the application of the convention. One is when, so Article 1, 2A says, well, this convention does not apply to settlement agreements concluded to resolve a dispute arising from transactions engaged by one of the parties as a consumer. So in other words, this convention only applies to commercial mediation settlement agreement, but exclude consumer mediation settlement agreement for personal, family, household purposes. Those will be excluded. And the second, Article 1, 2B says relating to family, inheritance, or employment law. So in that case, if let's say a substantial Indian family business, right? So it's a business, but it's a family-run family business. What if they have some disputes among the different shareholders? And this Indian family happens to have family members who live or reside, places of business, right? Place of business resides overseas. And in that case, would this convention be excluded or not necessarily? So inheritance has been excluded explicitly. Employment law excluded explicitly. And then the third one, so Article 1, paragraph 3, also provides the exclusion of the application of the convention in the context where the settlement agreements have been approved by a court or concluded in the course of proceedings before a court. Now, I pause here because I do not have enough knowledge or information about the Indian court system. But if I assume that the domestic, Indian court systems is quite similar to or maintains the English, common law style, I suspect that in your current civil, practice, civil law, civil court practice, you do not have. Normally, I will be surprised that if you have the mechanism for the court to approve any mediation settlement agreement. But I will be very interested to hear from you, either in the chat box or later in the Q&A session, whether that's the case. So most of you, or at least some of you, may be raising your eyebrows. What kind of settlement agreements will be approved by a court? Now, immediately, those of you who have the family law practice experience, you would think, well, typically in family mediation, right? So that's potentially when the family mediation settlement agreement deals with involves the children's interests and welfare, then they will need approval. But how about commercial? Is it conceivable in your system that a commercial mediation settlement agreement will be approved by a court or concluded in the course of proceedings before a court? What does that mean, in the course of proceedings before a court? Now, I would say that because of my experience in the mainland Chinese law, so my first law degree, I obtained my first law degree in Shanghai, in mainland China, many years ago. So according to the mainland Chinese legal system, that's a very common occurrence. In fact, within the mainland Chinese civil procedure law, there is a whole chapter that deals with the mediation. Okay, so it's court-conducted mediation. So the mediation will take place in front of a judge. commercial, okay, not just family, but civil procedure. And also recent years, there are possibilities for you for the court to not only to conduct the mediation within the civil procedure law, but of course you can also enforce the mediation settlement agreement that's reached outside of the court system, but they can come to the people's court to ask the court to enforce those commercial mediation settlement agreement. So this clause has excluded explicitly those mediation settlement agreement, which in my opinion, personal opinion, is a shame. I think it's such a shame, because otherwise a lot more mediation settlement agreement could be potentially enforced under this convention for certain systems, such as the mainland Chinese legal system. Now, in Hong Kong, on the other hand, so because I was called to the bar in England and Wales in 2005, so I've got the common law, English law background, and I have lived and worked in Hong Kong since 2009. So here in Hong Kong, on the other hand, probably similar to your practice there, the court typically would stay the court proceedings and then let the parties go and do their mediation, and if that's what the parties want to do. Or maybe you have some practice directions that will encourage or suggest, suggest the parties should try mediation first. But nevertheless, all those, well, the other one is concluded in the course of proceedings. I think this could be potentially controversial. What does that mean, right? Settlement agreements concluded in the course of proceedings before a court. Does that necessarily exclude the one that I just mentioned? The mediation settlement agreement was reached in the course of the proceedings before a court, but outside the court proceedings, in the sense that they stay the court proceedings, but then the parties go and find a neutral third party to mediate, okay? And then the Article 1(3)(b) says settlement agreements that have been recorded are enforceable as an arbitral award. I think that's very clear. So basically, if it's a settlement agreement that's reached in the arbitration proceeding, but I think that the way that these three, Article 1, Paragraph 3, A and B, and especially the small Roman 1 and small Roman 2 under A, the way they phrase are quite interesting, because for Article 1, Paragraph 3 and small Paragraph B, it directs to the settlement agreements being recorded and are enforceable as an arbitral award. So no arguments about whether the arbitrator has acted as the mediator, for example. It doesn't matter. As long as the settlement agreement have been recorded and enforceable in the award, that's what would make that settlement agreement being excluded. But the Roman 1 and Roman 2, I think, could be potentially, not entirely clear, because bearing in mind different legal traditions, different legal systems have very different practice in their civil court proceedings when it involves mediation. So I'll give you another example, because previously I've been involved, I actually had a book, I published a book, co-edited a book on mediation in Asia Pacific. It's published by Kluwer. So, I don't know whether it's still available in the market, but in that book, we have looked at about maybe 12 or 10 jurisdictions. We look at the mediation practice in 10, 12 jurisdictions. One of them I remember was the Korean, South Korean, Republic of Korea, their mediation practice. And in their practice, they also have this called court-annexed mediation. So it's not conducted by the court, by the judges. Yeah, so they have, on the one hand, like mainland China, they have judges conducted mediation. That's one type of mediation. For those mediation, they are equivalent to court judgment, so will be excluded by way of the Article 1, Paragraph 3, and small Roman 1. But they also have the annexed. So in other words, probably would be counted as approved, right? So what does that approved mean? Or concluded in the course of proceedings before a court. Anyway, I think that all these questions remain to be clarified. I think if we get some case law, hopefully, eventually or in due course. So I think that for the scope of application, I would probably just quickly introduce these questions as food for thought for you and for all of us to think about. There is no answer, I think, at this moment to all of those potential controversial questions. And then don't forget, of course, Article 2 is also relevant, because in Article 2 definitions, it deals with some of the concepts in Article 1. For example, it explains for the purpose of Article 1, the place of business, right? So if let's say an Indian company, it's a international Indian company, it has places of business in Hong Kong and also in mainland China, in London, all over the world. And so how are we going to deal with that? Then it says, unsurprisingly, that the relevant place of business will be the one that has the closest relationship to the dispute resolved by the settlement agreement. Okay, and then of course we know lawyers will always debate about what is closest relationship, right? And how we're going to resolve those issues, and according to what law? So closest relationship according to the law of where the settlement agreement was concluded, or closest relationship according to the law of the nationality or the place of business, right? Given that the issue deals with the place of business of the party. So naturally you would think, well, okay, because it deals with the place of business, then are we applying the law of the place of business to decide which place of business has the closest relationship? Yeah, so not watertight. There are potential issues there. So, and then it says, if a party does not have a place of business, then it will be the party's habitual residence. Okay, so, and again, this another concept of habitual residence. We already mentioned the settlement agreement needs to be in writing. I think that's quite clear. And of course, in writing, nowadays would be very widely defined. So here it explicitly provides, okay, electronic is fine, okay, as long as it's accessible, usable for subsequent reference, that's okay. And now then the next definition, the mediation, right? So I already mentioned, because of this international aspect of the subject matter, mediation. We mentioned earlier, the court system may deal with the mediation process separately, but even the concept itself, the concept of mediation itself, may well differ from jurisdiction to jurisdiction. So for example, in Hong Kong, we also have conciliation. Okay, so there is a separate ordinance. And so what's the difference between mediation and conciliation? And those of you who are familiar with the United Nations conventions and model law instruments, that you would recall, you would be aware of the previous, the model law on conciliation, the previous regime that we use conciliation and mediation interchangeably. But for certain jurisdictions, I think there are some differences there. So, and again, for the purpose of the Singapore Convention, it says the mediation is a process irrespective of the expression used. So it doesn't matter how you call it, or the basis upon which the process carried out, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third party, the mediator, lacking the authority to impose a solution upon the parties. Now, immediately, those of you who are accredited mediators, you will be wondering, so am I going to be okay if I use evaluative skills, right? So thus the Singapore Convention differentiates the differences between evaluative mediation and facilitative mediation, right? So again, so those skills techniques, if I'm simply facilitating, in other words, I'm not giving any authority to impose any solution, that will be okay. But if I use evaluative skills, even though I'm evaluating, nevertheless, I'm not imposing. I'm not advisory. And how about advisory? Now, advisory has not been mentioned in Article 2, paragraph 3. So does it mean advisory is okay? As long as I do not impose my solution, I'm only advising, but it's still up to the parties. Would that be okay? Right? So I think that these are some of the interesting aspects or topics that I think we may or may not see cases coming in the future. So that's all I want to talk about for the first topic on the scope of the convention. And how am I doing with my time? Can our moderator give me a hint? Do I still how many more minutes do I still have?
You can go for another 10 minutes.
Okay, right. So I have 10 minutes to quickly cover the second topic on the future of mediation. I think what I would like to do, I would quickly refer you to Article 5. Okay, so in Article 5, so those of you who have the convention in front of you, you look at Article 5, it deals with the requirements of it deals with the sorry, I'm waiting. Grounds for refusing to grant relief. So we're talking about the enforcement of international settlement agreement that reached by mediation. Then when these settlement agreements comes to national courts, say when, let's say, a Hong Kong parties, a party whose place of business is in Hong Kong, and they come to India, present to the Indian courts this settlement agreement that was reached in Beijing or mainland China, in Hong Kong, and they want the Indian court to enforce this settlement agreement. And how would the Indian courts deal with this application? Now, I am aware of the fact that India has not yet ratified the convention, although you have signed on the Singapore Convention, but probably still going to take a while before you formally ratify this convention so that the convention becomes part of your law. So if we look at Article 5, I want to quickly draw your attention to the Article 5, paragraph 1, paragraph 1 and subparagraph E for echo, E for echo, and also subparagraph F for Friday. So E and F deal with the mediators, yeah? Because I think that's probably what most of us will be most interested. E says there was a serious breach by the mediator of standards applicable to the mediator, or the mediation without which breach that party will not have entered into the settlement agreement. So we're talking about the standards applicable to the mediator or the standards applicable to the mediation. Now, those of you who are also have extensive experience in arbitration, this looks similar, or in a way that we will have this standards applicable to the mediation. What does that mean? Now, standards applicable to the mediator, it's easy because let's say for the Indian, I don't know if you have your bar association, then you will have, like, for example, I take Hong Kong as an example. So in Hong Kong, we have let's say the Hong Kong Law Society. They would have their own guidelines, and I think I also come across a code of conduct, yeah. So they will have, of course, they will, for example, those arbitration centers and mediation centers, they will have their rules, but also for certain, you will have some code of conduct or best practices, right? So how about those code of conducts? Are they the kind of standards that we are talking about? But even for code of conduct, and then we also have those softer ones. When I say softer, I mean guidelines. They are not enforceable in the sense that, like code of conduct, the members are abiding, right, by the code of conduct. But if they're just guidelines, are they the standards applicable to the mediator? And what's the standards applicable to the mediation? Are we talking about under the rules? So if this mediation is conducted under, let's say, HKIAC rules, then are we saying the standards within those rules applicable to this mediation? So in that case, if there is a serious breach, then the Indian court would say, sorry, we cannot enforce this international settlement agreement pursuant to the Singapore Convention, right? But then we need to really go into the standards applicable to the mediator and standards applicable to the mediation. What do we mean by that? And where are they? Do we have the standards applicable to the mediator practicing mediation in India? What are your standards, various code of conduct, guidelines, and all that? And the subparagraph F, there was a failure by the mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality or independence, and such a failure to disclose had a material impact or undue influence on the party, without which failure that party would not have entered into the settlement agreement. So again, there are lots of tests here, right? So the justifiable doubts and impartiality, independence, and naturally we expect this from a competent mediator, and failure to disclose. But that need to be, having a material impact or undue influence on the party. So I think I just want to quickly highlight these two subparagraphs in the hope that to point out, if we're looking forward, looking into the future of the mediation, it seems like at least the Singapore Convention suggests that we need to be paying attention to the accreditation standards, the training standards of mediators, right? Because otherwise, the mediators, the resulted settlement agreements may be challenged, may not be enforced. That in itself would be a ground that would justify the refusal of enforcement of the international settlement agreement. But then you can imagine immediately, this is going to be so difficult to achieve. Now, I don't know how difficult or how easy it is to achieve within India to have a uniform standard that applies to all the mediators practicing at least commercial, right? We're not talking about family mediation. Let's say commercial mediation. Do you have one uniform standard rules, procedural rules, guidelines, or code of conduct? What kind of standards are we talking about? Now, and think further, across all the jurisdictions, right? So potentially, how are we going to agree on the standards applicable to the mediator? Is it better for us to lower the standards so then, at least we will make most of the settlement agreement more enforceable, more likely to be enforceable than not? So I think all these are not easy, that there are no easy answers there. But I just want to quickly conclude. I reckon if my time is running out, I would quickly share with you, bring to your attention that, for example, in mainland, in the Greater Bay Area, we have the Greater Bay Area Mediator Accreditation Standards. So that's the standards. We have the Greater Bay Area Mediator Code of Conduct, best practice. Now, this is a bit awkward because it's code of conduct sounds more powerful, but then it says best practice. So best practice sounds like, you know, it's the best, but if it's not the best, but still, you know, reasonable, acceptable practice, would that be okay? And then, of course, we have HKIAC, we have the mediation code. That's one of the most well-known one. It's really set out all the general responsibilities on the mediator and the responsibilities to the parties. And a more international one, you will all be familiar with the CEDA, the Center for Effective Dispute Resolution. So CEDA has published its mediation guidelines and procedures. So there you can find some standards there. They have also model mediation procedure. Okay, so I would just probably stop there. I think that now I have this last document in front of me. It's published by CEDA, Center for Effective Dispute Resolution. It has a note of caution on the ratification of the Singapore Convention. So it highlights some of the issues that from CEDA's perspective, they are considering, although lots of states have signed the convention, but no state has ratified. I think that was back in 2020, but we know some states have already ratified the convention. So the origin of settlement and the Singapore Convention. Yeah, so just for some information. So food for thought. I will stop there. Okay, thank you.
Thank you, Dr. Yang, for a very insightful and concise address on the applicability and future of the convention. Now, I would request Mr. Robert Gerrad for the second leg of address. Before inviting him, I'd like to give a brief account of Mr. Robert Gerrad. Mr. Robert is a senior NEC consultant and secretary NEC Users Group, accredited mediator and dispute resolution advisor. He's also an honorary advisor to the Hong Kong Adjudication Center and senior certified adjudicator at the International Dispute Resolution and Risk Management Institute. Robert specializes in NEC contracts, both setting these up and successfully managing them. He has 40 years experience in contract management and carries out training and consultancy around the world. Robert is based in Hong Kong and works as a senior consultant for Thomas Telford Limited. He's an examiner for the Institute of Civil Engineers Certificate in Law and Contract Management course, and has also held the position of NEC Users Group Secretary from 2006 to date. Robert was an NEC 4 contract drafter, part of the NEC 3 contracts working group, and an accredited NEC 4 ECC project manager. He has several publications in his name surrounding his expertise and experience. So with all this, I request Robert to take the floor and address us. Over to you, Robert.
Okay, thank you very much indeed. And also it's my pleasure to speak to you all today. So my angle's a little bit different to that Dr. Fan talked. So I'm going to talk about skills of a mediator, and actually how useful and portable they are in day-to-day life, as well as in mediation, as well as in other industries. And the industry, so the two sort of things that most get me excited in work related are mediation and NEC 4 contracts. So this talk really is about, you know, how or can I apply or deploy mediation skills if I am managing contracts. I'm going to particularly look at construction contracts. That really is my background. So so a little bit about me. Ralph's just mentioned all of that. The last one, I'll just point to the last one. Well, I've got no hair left and I'm really old, and I've just decided to do a master's degree in law at Newcastle University, so I must be completely mad, but never mind. 1 year of a 2-year course. I'm very interested, but actually it's a master's in law in mediation and international dispute resolution. So again, I find it quite fascinating. So I started my career off in construction in the UK, in large civil engineering type projects, and you get to watch people do this, and it is just crazy. And the training you get, the education you get, is basically sort of warfare type education. This is how to prepare a claim, reject a claim, do a counterclaim, write a defence, and all sorts of things. There's nothing really about collaboration, about the right sorts of human behaviour that is likely to lead to the best results. And much of the education, certainly I received, was pretty useless for today's environment. Today's environment, the world throughout, really, apart from the odd war going on here and there, is more about collaboration than adversarialism. And of course, mediation, one of the beautiful things it does, apart from healing wounds and problems, is to bring people together, to find that common ground, to find something that works for both parties. So I personally stumbled into mediation about 7 years ago and had a dispute with an airline who left me in an airport and then abandoned me and didn't really care less after when engaging with them. And I took them to a small claims court, and it was in the UK, and the small claims court said, oh, go and try mediation first. So before then, I was taking my career into arbitration or possibly adjudication, and I fell into mediation, and I thought, wow, this is absolutely fantastic. So very quickly after that, I became an accredited mediator myself, and have practiced ever since. And I think it is a wonderful tool to help people resolve disputes. So I believe passionately in people, and I feel that people often need the chance to speak in litigation, adjudication, arbitration. The dispute is taken away from them. The decisions are taken away from them. They're just pushed to one side. That's my personal opinion of these things. And they should be central. Surely it's their dispute. They have to be absolutely central to finding a way out of their dispute that could have cost them a lot. Could have cost them their business. Could have cost them their homes. Well, one dispute I mediated, a guy was so anxious about the outcome. They were going through court. The court said try mediation. He was so anxious about the outcome. He'd suffered 2 heart attacks. Horrendous. You know, the suffering that people have in disputes is horrendous, and we generally do not factor that into the outcome in arbitration, litigation, or adjudication. Hence my love of mediation. So, enough about me. What we're going to talk about first is just quickly introduce you to NEC 4 if you didn't already know. And let me type something here. Have a look at this website. No idea how many, if any of you are involved in contracts, but do have a look at NEC 4, which is not just construction contracts. I'll explain that very shortly. Contracts for purchasing all sorts of things. So, you know, I feel the world throughout is going through, you know, one of its countless cycles of revolution, and now we think we're back to believing that actually collaboration is a good place for us to be, and that really is what these contracts are all about. So we look at what is NEC 4. A quick reminder of what is mediation. You won't need that, I do believe. Some of the key features of NEC 4 contracts and how we go about managing them, and then really step back and look at, you know, what skills ideally the mediator needs to have and to have at their disposal to use in a mediation, and see if there's a connection. If you learn mediation skills and you are a construction industry practitioner, could those skills help you manage contracts better? But not actually just construction. The fact that I'm from construction is why I've majored on it. But frankly, if you are managing any contracts at all, can you deploy mediation skills in the management of those contracts? Question, you know, maybe it's a thesis for somebody, I don't know. So if I'll get this to advance, there we go. So what is this thing called NEC 4? Well, it's a suite of contracts. It's actually can be used the world throughout for the global purchasing of works, construction works, airports, roads, hospitals, schools, housing, and any sort of works, any services. So the maintenance of those very assets that you've just procured, or facilities management, those sorts of things, or the purchase of people to do design or write reports, so professional services, as well as construction industry type services, and also supplies if you want supply of trains, planes, or automobiles, nuclear reactors. Worked on a supply of a wheeled crane, a mobile crane for a port in Guernsey, things like that. So goods, services, or supply, these contracts are geared up to. So they're about getting people to cooperate, getting people to use good faith. A very important sentence is the very first one, which is about mutual trust and cooperation. So the concept of good faith is at the heart of these contracts. Good faith, of course, is not prevalent in many laws, in many countries, certainly not in Hong Kong or in the UK. And Australia. There's probably three main countries that I work in. So NEC4, why is it called 4? Well, so NEC is also a computer, name for a computer type or electronics giant, isn't it? Also, it's a place in Birmingham, where I'm from, originally in the UK, called the National Exhibition Centre. And also it's a range of contracts to be used for the procurement of goods, works, or services. 4 basically means it's the 4th edition of this suite of contracts. And they have evolved. So the very first edition was really for construction. It's evolved over time to provide different contracts for purchasing of different things. So now within this suite of contracts, and there's a lot of these contracts, you can procure an alliance, a framework, a DBO contract, short-term consultancy, maintenance, supply agreements, so on. A big feature also, so we're often quite used to as within our industries with lump sum contracts, schedule of rate type concepts, but also we've now introduced like cost reimbursable, target cost contracts. So the world is also opening up more transparency, more auditability of cost. So it is basically a matrix of options that you can use to design and build your own sort of your own contracts to suit the particular agreement that you want. So think NEC for good faith contracts for procuring goods, works, or services, but need to be professionally managed. We don't pitch these at the sort of homeowner type marketplace. There's something that need professional management. Biggest project I've personally worked on would be the Al Raha Beach in Abu Dhabi. I think at one stage it was about $17 billion US. I've done some training on the UK high speed 2. I've no idea these days how much that is. 100 billion UK, something like that, chopped into 300 or so different packages, but a huge program of works. So the one contract I will focus on for today is called the Engineering and Construction Contract, that abbreviates to ECC. Lots of abbreviations in the world of NEC. So you use this when you're procuring large or complex construction engineering type projects. I mean, Hong Kong, it is the contract of choice by the Hong Kong government. It's also used, for example, at the airport. The new 3rd runway was built procuring using the NEC contracts. All of our underground, our railway operator called NTR is procuring all of its new stations and lines. You're using NEC, and just about all the public sector works are using NEC as the basis. So what is mediation? Well, you all know about mediation, don't you? So it's a process used using a neutral third party like myself or yourselves called a mediator. What do we do? We're trying to help 2 or more parties in a dispute to reach a mutually acceptable resolution. So what do we do? I'm a bit old school, a bit of a mediation purist here. I'm a facilitative mediator. I don't like evaluative mediation. I like the concept of it. I wish it wasn't called mediation. I do like the concept of it. I won't do that. I won't practice in that. And I'll separately tell you about that another story another day if you want. So what we're not doing, and Dr. Fan mentioned this, we are not making the decision. We are not imposing solution upon the parties. Okay, we're trying to help them explore an option here as a way to resolve the dispute. Often will involve money, sometimes not money, sometimes could be, you know, the next contract or something like that as the means to resolve the dispute itself. What I love about mediation is the future focus, and rarely, if ever, will I look back at the documents. I'm not here to judge or decide who did what wrong. I'm here to help you find a way forward. And you've spent a long time looking back, and looking back hasn't helped you. That's the beauty to me of mediation. Forget looking back. Let's just look forward. It is what it is. I can help you do absolutely nothing whatsoever about yesterday or last week or last month or year. What I can do is help you look forward and climb out of the hole that you're in mentally with that dispute, and try and actually find something that you can live with and get on with the rest of your lives. So my experience is it is far less formal than arbitration litigation. It is definitely less expensive than arbitration litigation. It is definitely less time consuming. But will you get the true justice that you think you need? If you are adamant you need some sort of acknowledgement by the court and a nod of the court order, then go to court. But 9 times out of 10, you don't need that. You just need to get over the dispute that's in front of you now. Where have I got these words from? I stole them. I'm trying to give credit from Sage Poet. So that's artificial intelligence, isn't it? What I've found so far with artificial intelligence and mediation, that actually is going to be the subject of my dissertation next year. I'm going to look at the advancement of mediation. The Singapore Convention will help that. But I'm also, in my opinion, looking at the plight of the mediator, because I think they're in trouble, because I think I'll be replaced by artificial intelligence one day. And when I've consulted artificial intelligence about this, I've asked them, would they mediate my dispute? And it says no. I think it means no, not yet, or not right now. So I think it will potentially definitely has the potential to be a mediator at some point, artificial intelligence, which I think is a good thing. Mediation, I'm aware of, has been taught at schools in the Philippines. I think that's absolutely fantastic. Let's teach people to solve their own disputes. Why do you need me? You don't need me. Develop your own skills, mediate your own disputes. I'm here to help people raise awareness of mediation and help you with mediation right now, but I shouldn't be needing the future. When we start, teaching mediation in first degrees, when we start teaching mediation at schools, as we're finding the Philippines are doing, when mediation becomes the bedrock of dispute resolution, which I truly believe it will, you don't need me anymore. So there you go. I'm getting old and need to retire anyway. But so how do you reference artificial intelligence? Be careful if you are studying at the moment, you're using it. Obviously, you have to give credit, don't you, as you would do with any other sort of formal recognition repertoire. Now, the problem I found with artificial intelligence is that if I typed that question again, what is mediation, I might get a different answer tomorrow. So it's ever changing. I'm not too sure how you can ever lock in a correct reference other than say the date which you obtain that information. But anyway, that's not really the purpose of this this talk. So I've told you what NEC is. I've told you what mediation is. I've only got about 12 or so slides. It's not much of me, don't worry. So go back to NEC 4 contracts. So with that ECC contract that I mentioned, we have somebody called a project manager, PM I've called them. But there's somebody called a client who's in contract with somebody called a contractor, a buyer and a seller. And we have some called a project manager. Effectively, it's a bit like the engineer with FIDIC contracts, or basically contract manager. They are there to manage the contract between the client and the contractor. So a few rules and a few things they have to abide by. They have to act as stated in the contract. Contract tells them to give a payment certificate, let's say the first of each month. That's what they must do. Contract tells them they must notify an early warning or an ambiguity or an inconsistency in the contract. That's what they must do. You must act as stated in the contract. You must also act in that spirit of mutual trust and cooperation, which is Humphrey Lloyd QC once called that a strand of good faith. I like that. I like the concept of good faith personally. I wish everybody acted in good faith at all times, but we don't. The world throughout, we do not. There's a lack of trust between us. We're not generally dishonest, but we hold information back. And I find as a mediator, holding information back is almost as damaging as lying. So I will impress upon people the importance of acting in good faith in a mediation. We're definitely not there yet in the construction industry. So whilst Hong Kong, China is obviously, you'll have read about it, having a big purge on corruption and bribery and things like that. Good faith is not just about the reverse of corruption or bribery. There's so much more to it. But how do we get into people's attitude and mindset, that sort of good faith concepts, that openness, that transparency and things like that? How do we get mutual trust? How do we get cooperation? How do we build upon these behavioral skills that people need to have in order to do their jobs better? Very interestingly, if you look at most people's conditions of engagement, they will use the word honesty or maybe integrity. And I guarantee if you join an institution, a professional institution, they will throw you out if you do not act with honesty and integrity. So that to me, that they are strands of ethics. Ethics is really important to me. Without ethics, we have nothing. We're all of us professional people are just an empty box. So you have a pull from your employment organization and from your professional body to be ethical. So actually acting with mutual trust, cooperation, good faith, I know different words, different meanings, is very much in line with the expectations that people act ethically, which they generally do not do in every other contract I've ever had the experience of. So other things the project manager must do, they must notify early warnings, they must certify payment. They must determine, you must try and agree with the contractor the effects of change, additional works, things like that. And if you can't agree with the contractor, you must set it. You must set it in a timely fashion. And when you're setting it in a timely fashion, you must not act as a bully. You must not take advantage. You are there to be basically even-handed, to hold the balance between the parties. But you are in a decision-making capacity, just like when you certify payment or when you ultimately determine the time and cost effect of a change in a contract. So very different role to the mediator themselves. Struggling to advance. Here we go. What we also must do, check the contractor's design. If the contractor is asked to be a designer, to make sure they've applied with the applicable law and the scope. Scope is what the client wants the contractor to deliver. Check the contractor's program can be accepted. We don't use words like approve. Approve are dangerous words. Make sure it's realistic. Make sure it complies with the scope. Decide the date of completion, again, acting in that impartial, independent manner. You have the right to change the scope, change what the client wants, do lots of things. But I would say that the most important job you have to do as the PM, the project manager, is to act as what we call an independent certifier. That person holding the balance between the parties. Very, very important role indeed. Oops, now, struggling to advances. So, so what skills do we need to act as mediator? Lots and lots and lots of them. Those of you that are mediators probably can reel off 20 skills that you have, that you had or you developed in acting as a mediator. Those that are studying, you will need to understand the many different skills that you need to act as a competent mediator. You must act neutrally, impartially. In fact, quite a lot I've read recently says it's very difficult, if not impossible, to always be neutral and impartial. Again, some of these are really good, interesting areas. Those of you looking for topics to do a dissertation on, can you always act neutrally, impartially? What if you hold one share in a company to which you're acting as mediator? If in doubt, disclose to the parties. Most of these things should not harm you in your role as mediator, but always, if in doubt, say something. Say something. You might have experience of certain disputes in the past. You may be drawn to something. I mean, but the ultimate safeguard for you as a mediator is you are deciding absolutely nothing. But you need to be seen to be neutral and impartial. You need to be seen to giving people equal amounts of time, things like that. You need to have good listening skills. A lot of times I'm in meetings, people are not listening to a word you are saying. It's quite clear. I quite like pens down approaching in meetings, not just mediations, but mediation meetings themselves, construction industry meetings. Pens down, listen. We don't all need to write the same things down. Maybe you need one top set. Maybe you even record the meeting. If you're so paranoid about recording every word that somebody says, record it, but by voice and or by video. You need to be empathetic. You be careful, not need to show too much sympathy, shall we say, but you need to have a heart. You need to have a soul. You need to act as a human being in mediation and be empathetic. You also need to know about negotiation, at least to understand what tactics are being used. Well, what I've found is that generally most people are absolutely terrible at negotiating. They've had no formal training. They're really bad at it. Now, it's not for you to tell them how to negotiate, but people miss a trick. If they don't go into a mediation understanding the basics of negotiation, they can come out with not as good a deal as perhaps they could have got if they were well trained in negotiation. You need to be calm. You need to be patient. These are some of the skills. Can you learn to be calm and patient? Probably. I think the more of these you can tick off before becoming a mediator, the better chance you'll be of being a mediator. But be calm and patient. Sometimes be persuasive, but be careful. Again, you're not the decider, but you might need to persuade people. Certainly I would persuade people, look, if you do want to walk out the door, if you do want to end the mediation, just be absolutely sure about that, because tomorrow when you kickstart litigation again, that is going to bring a whole lot of time, cost and stress to your life that you perhaps are not prepared to do. You need to be good at communicating. I try not to do written form. I try not even to take any notes or take a pen in. I'm there to listen. I'm there to help you with the process. I'm there to help you focus on the future. I don't need to write things down. However, that said, sometimes there could be lots of different strands, lots of different options. So be good at communicating. You need to have that future focus, though. You need to be a good problem solver. You need to have skills, that will help you here. You need to be able to comfortable optioneering and balancing things out with the participants. But again, you decide absolutely nothing. But you may say sometimes, I think we need a tea break or a walk. Walks are good. Fresh air is good. Tea breaks are good. You might say silence is good. I like silence. Be comfortable around silence. You don't have to keep talking. So there's some of the skills you have. So matching those things up. So, the last few slides, where you're acting as stating the contract and you're using mutual trust cooperation as required by the NEC contracts, then that fits reasonably well with that sort of neutral impartiality requirements of mediation. Early warnings is a whole host of things here. What's an early warning? It's a part of a risk management process. We are sharing usually in bad news with each other. Here is some bad news. Let's work together to solve a problem. The mediation skills here that fit really well are listening to what the contracts are saying to you, showing some empathy, being calm, being patient, being persuasive of a good solution. So here now, it's not quite directional, but you could be directional if you so wish to in NEC, but again, not in mediation. Good at communicating, good at problem solving, and so on. I mean, maybe I don't need to go through all these, but you can see that all the things that you need to do in an NEC4 contract or FIDIC or any other construction contract or any other contract to do with anything, there's a whole host of mediation skills that you can deploy in the active and professional management of that contract that you're working on. So what is my angle here that really, I love mediation to bits. Getting jobs as mediators is sometimes quite difficult, but if mediation is your side job, not your main job, you will be amazed at how many times you can bring in those really good mediation skills to help you navigate your way through a construction or other contract. So what I say to people is, whilst you may not want to be a mediator, you will want to hear about the process. You will want to develop some of the skills that are definitely beneficial, frankly, in your life. Arguments at home, arguments with your kids, arguments with your loved ones. Try and mediate. Try not to fall out and dispute. Use those skills that you've learned. So other things in the contract: accepting contractor's design, accepting the program, deciding the date of completion, changing the scope. Again, there's a whole host of mediation skills that you can use to help you navigate your way through a contract. That's pretty well it. So mine's a slightly different angle to say that ultimately, even if you don't wish to become a mediator, maybe it's not quite your bag. The skills that you've got should help you in your primary career, and vice versa. You know, well, people often don't learn mediation. It's not their first career, but their second or third career. I think one day we'll perhaps a bit like project management. You know, I didn't start off as a project manager. I started my training as a quantity surveyor. Then became a project manager. So here I became a quantity surveyor to become a mediator. I think we can draw upon these great skills we can learn in mediation to either be that mediator or to help you manage contracts that you're associated with. By all means, connect on LinkedIn. Here's my email address. I'll happily share the master's degree information I'm doing at Newcastle University. Any questions about mediation or NEC contracts, give me a shout. Any of you work in an environment that would benefit from an NEC contract, I will gladly spend some time. So I'm very passionate about helping people solve problems. Yeah, we need to learn how to work together constructively, honestly, in good faith to solve problems and create great outcomes. Rahul, that's me done, I think.
Thank you, Robert. Thank you very much for a very insightful address. It was really a delight to hear you on this new concept of NEC4 and the need and requirement of the mediators in mediating and deciding the disputes. It was wonderful to learn about the role of the project manager, who needs to be ethically strong because he plays a major role, maybe a role. He's bridging the client and the customer. So that was really insightful. We really loved your presentation. Thank you very much. Now we would move to the question answer session. We have some question in the chat box. I'll just take it. So the first question is for Dr. Fang. Mr. Wasiuddin wants to understand, does the convention define who the competent authority is? Because Article 5 mentions about the competent authority.
Yes, thank you. Thank you for the question. I just had a quick look. I don't think the convention itself defines competent authority, but typically in the context of public international law, because these are conventions and between signatory states, competent authority, I believe in this context, would normally be referring to national courts. Yeah, national courts. But then, of course, within a domestic legal system, it could be possible, for example, your domestic legal system will only designate certain courts or certain levels of courts to deal with the enforcement, of settlement agreements under the Singapore Convention. So, for example, in mainland China, you cannot go to the local, the basic court to do that. You have to go to at least the intermediate court to start enforcement of foreign arbitral war proceeding. And that can be subject to appeal or not appeal. So it really depends on the domestic legal system, domestic court system. But most likely would be the court. Would it be possible to have non-court as the competent authority? I am not entirely sure. Maybe, we don't know. It's not defined. Yeah.
All right. The next question is for Robert. Robert, since the project manager plays a very vital role in the contract between the client and the contractor, so is there any test to determine that the project manager is ethically strong, or what criteria do you take into consideration in hiring a project manager?
What a great question. Be very careful, make sure they are highly competent, make sure they are fantastic human beings who are not afraid to make decisions, who can act in an independent and impartial manner, who are good leaders, who respect people, actually have a whole bundle of soft skills, they don't need to be the ultimate problem solver or know everything about the whole world. So we're not looking for the world's best planner or designer. Or, we're looking for people who are honest enough with their own skills and the skills they haven't got, and who are not afraid to call in other people to help them make decisions, but they need to be good, competent decision makers. We've actually developed what we call an accreditation course. So we accredit project managers. Now, I'm not saying if you're accredited, then you're perfect. It's a part of a whole series of things. If I were a client, I would put my project managers through, basically a strongman, an Ironman test, iron person test. You need to be able to demonstrate all sorts of skills and competencies, because you're about to manage a contract. Sometimes these are just, like I said, the UK ones, what I worked on, 10, 20, 30 billion US dollars. It's just incredible amounts of money. And if you're doing it on behalf of the public sector, then the public sector have a right to have their hard-earned tax dollars spent wisely. So we need to create a brilliant group of ECC project managers. And I think the accreditation is the first step in that. I think we need to realize that, you can't just put the most senior person in the office, or the one with the least hair, or the one with the most years of experience. It is competence, and we need to determine what is that degree of competence that's needed. I hope that's helped. But it's we need to be very, very carefully did, and I don't think we have been historically.
Thank you for your answer, Robert. We have a question from Mrinalini, and this question would be for Dr. Fan. She wants to understand if the mediation agreement under the Singapore Convention is disputed on ethical grounds or fraudulent intent. What shall be the place of jurisdiction and applicable law for disputes arisen in India, or that dispute is between Indian parties?
Thank you. I think that first we will need to differentiate two agreements here. One is the agreement that's called mediation agreement. That's the agreement that the parties have agreed that if they have any disputes, they will submit their dispute to mediation. So that's called mediation agreement. But the Singapore Convention is enforcing also the settlement agreement. In fact, the settlement agreement is the subject matter. And of course, by enforcing the settlement agreement, you are also enforcing the mediation agreement. So the second agreement, it's called either mediated settlement agreement, which is the term that I would prefer. It's not just any settlement agreement, because parties can reach a settlement agreement with their lawyers' help, without mediators, with or without mediators. But the key point here for the purpose of the Singapore Convention is a mediated settlement agreement. So in that case, so we're talking about the mediated settlement agreement. And these two agreements can be subject to or can be governed by different laws. They could, of course, parties can agree that this mediation agreement will be governed by Indian law, or they could agree this mediated settlement agreement will be governed by certain law. So we're talking about potentially, different laws, different applicable laws here. So if you go back to your question, if you can rephrase your question, just clarify which agreement you're talking about and which applicable law you're talking about, right? And then, of course, we also have this, the mediated settlement agreement will potentially could also have the law that governs the mediation process, the procedure, right? So we have the agreement to mediate. That's a similar, in a way, similar to the jurisdictional clause to say that dispute, no submission to arbitration until they try mediation. If they fail mediation, 30 days, 90 days, they can go arbitration. So in that case, the mediation agreement is a standalone. It has the jurisdictional impact. But if then, after they enter into the mediation process, you can potentially have a law that applies or that governs the procedure. So if, for example, although the parties have agreed to conduct the mediation in India, but they have also agreed to adopt the Hong Kong HKIAC mediation rules, for example. And in that case, how would that impact upon the procedures, right? So if they have applied the HKIAC rules, would that mean that First, I think we'll possibly also ask the question, does Indian law have any mandatory procedural requirements on any mediation conducted in India? So this goes a bit like the arbitration regime, whether we have this concept of seat of mediation, seat of arbitration. So all these are quite unknown. Right. I'm not sure I answered your question, but if we can have further follow-on discussions.
Right. I think you have answered it. So the next question is to Robert. Robert, so our guests and participants wants to understand if there is any accreditation course you would like to refer to them, more specifically for construction disputes, or any reading materials which you would want us to read.
I mean, it's on the NEC website. I'll put it on again. In there, there's a whole part on training and accreditation, things like that. But really, we're trying to get people to understand how to manage a contract, not how to mediate. So, in fact, only one NEC contract actually refers to mediation. So the problem with mediation is we need governments to agree it's the best way to resolve most disputes, or it's the first place you should go. Whereas actually, a number of governments, the first place you should go when you have a dispute is adjudication, certainly in construction. So in Australia, Singapore, now Hong Kong, or parts of Hong Kong, or parts of Ireland, UK, where else, that New Zealand, then we have acts which say when there's a dispute, either party has the right to go to adjudication, not to mediation. So I think we have to impress upon corporate HR people in particular and in-house counsel to say, to implore them, please, at any time, please try mediation before you press that go legal button and you end up, in adjudication or litigation or whatever. So it's if you don't know about mediation, you get educated in it. And what we're trying to accredit people on is not mediation. I've been accredited in mediation, that's separate, but accredit them on how to act in the role of the project manager, which I think deploys some, mediation skills. So really, it's for those people who are working primarily in construction type contracts who will end up acting in that capacity as a contract manager. I hope that's helpful.
Thank you, Robert. I would now take the last question, which is for Dr. Fan. Now, one of our participants, Wasauddin, wants to understand if the parties can use this settlement agreement as an evidence under the applicable legal framework in case of differences, more precisely in light of Articles 18 and 19 of the Convention. And if they do so, what happens to confidentiality?
Thank you. I think that the question is referring to Article 18 and 19 of the model law, not the convention. So here we have two different instruments here. One is the convention itself. It's the Singapore Convention that deals with the enforcement of international settlement agreement. And the other instrument is called model law. And it's a newly updated model law. It's a 2018 version. Let me see if I can quickly find it. But if not, you would be able to find it online. So the Article 18 and 19 that this question is referring to is really the model law. So under the model law, it says these are the things that you can refer to evidence the. I believe that under the model law, this is explicitly provided as a way of evidencing there is a mediated settlement agreement, as opposed to just any settlement agreement that can be reached by the parties. And I think that also links to another question that I saw earlier in the chat box that relates to the weaknesses of the Singapore Convention. The reason I'm saying that was because from the very beginning, based on my limited experience in dispute resolution in general, I have always had doubt about the the need, for this Singapore Convention. I totally understand that the convention really raised the awareness of the use of mediation, really raised the confidence of the users to adopt mediation as a mechanism, like Robert also advocated. And I believe in mediation. Of course, I think NEC has the best, principles that will help parties to resolve their dispute peacefully and also effectively. But the problem is, within the regime, including the topics that I was spending time in the first part of my topic, the scope of the application, you can readily tell that the scope for the application of the Singapore Convention will be very, very limited. So let's put ourselves in the shoes of the parties. If the parties, they will manage to reach a settlement agreement, bearing in mind, the settlement agreement can be reached outside of the mediation process. So, for example, they have been through the mediation process for a week. So it's a week-long mediation. It's a big, huge project. They have Robert as the excellent mediator. But unfortunately, they didn't reach a settlement agreement at the end of the week. So they went away, they spent a month or 30 days. Then they decided, well, you know what, actually we should settle. Then they reach a settlement agreement, yeah? So in that case, would that settlement agreement be counted as a standalone settlement agreement, or is it still part of the mediation? Derived from, Robert's hard work, that week-long hard work really helped the parties to see the common goal, to see, each other's, positions and interests and concerns, but they just couldn't reach, a settlement agreement on the spot. However, 30 days later, they managed to do it. So you see, if they can reach a settlement agreement, that settlement agreement is enforceable in itself as an agreement. All that lawyers will tell you, right? It's an agreement, it's binding, it's enforceable as an agreement. And of course, in that settlement agreement, it can have its own dispute resolution clauses. It can say any dispute arising out of this settlement agreement will be subject to arbitration, the court, whatever. So if you have an agreement, you enforce it as an agreement. Why do you have to go back to say, oh, you know what, I want to get the Robert back and ask Robert to sign on this? And so I think that the scope of application would inevitably limit the usefulness of this convention. And also bearing in mind the commercial reality, maybe the cross-border elements would be the reason, or it's just a convention to raise parties' comfort level, so to speak. But the areas that when I was studying or when I was doing research on the cross-border enforcement of mediated settlement agreement, I was more focused on the court-related settlement agreement, because that's where at the moment there is nothing to help the enforcement, cross-border enforcement of court-related mediated settlement agreement. So either it's a court-conducted mediation, and of course, not all the system will be comfortable about that. And then you also have the court-annexed, right? So I think those are the areas that can really do with a convention that helps facilitates the cross-border enforcement. But if we're just talking about purely commercial agreement is an agreement. It can be enforced. Okay, I don't know whether that helps. Thank you so much.
Yeah, I think that's really helpful. Thank you, Dr. Fang, for answering all our questions, and Mr. Robert for taking your time and enlightening us on a very interesting and important topic of discussion today. Before we close and invite our participants for the last session, which is happening tomorrow, I would just briefly recapitulate what happened today. So Dr. Fang touched upon very important issue, which is the application and the scope of the Singapore Convention that has been tabulated and contained in Article 1. She discussed the contours of applicability as well as the exclusions which is contained therein. Apart from that, Dr. Fang also elaborated on and gave us a food for thought with respect to the process contained therein, which is evaluative, facilitative, and advisory mediation. Lastly, she touched upon Article 5, in more particular, the paragraph E and F, which provides for the standards applicable to the mediator or to the mediation, and the disclosure of impartiality or independence, which may be a ground for refusing to grant relief. So these grounds are more familiar to us because they're also contained in Indian Arbitration Act, more particularly Schedule 5 and Schedule 7, apart from the IBA guidelines and other institutional rules which provide and set certain standards. Moving on to Robert's presentation, he introduced to a completely new world of NEC 4 contracts, the role of mediation, and the most importantly, the role of the project manager in working as a bridge between the client and the contractor. He also tested the skills of the mediator, which one needs to have in more particularly in managing NEC contracts, and successfully helping and ensuring that such contracts work without any dispute, or if the dispute takes place, how that has to be resolved and what all qualities does the mediation need to have. So with all these brief insights, I thank both our speakers, Dr. Fang and Robert, for taking out time and being with us on this 9th session and enlightening us today on very important yet crucial topics. With this, I say thank you to everybody for taking out time and participating and being with us, setting up the stage high with your questions and testing us on some interesting questions and the insights that was given by the speakers. Tomorrow we meet for the last and the final session before the valedictory ceremony, which is on 2nd. Tomorrow we'll have Justice Vasisht Kokaram, who would be enlightening us on UN SDG goals and mediation. And with him, we'll also have our own Aruneshwar Gupta, Senior Advocate, Supreme Court of India. So do join tomorrow at the same time, which is 5 p.m. And before we close, thanks again to one and all present here. Thank you to all distinguished guests, speakers, and our own members of Nivaaran. Thank you very much.
Thank you. Thank you very much,
Thank you,
Dr. Fan.
Thank you. Good night. Thank you.
Thank you, Robert. I'm sure all the audience today will go home very satisfied and content. We only have very, our knowledge about the convention was not so much in detail. Now, after listening to you, I think a lot of questions arise in our mind, and I think we have gained a lot today. Thank you so much. Thank you for sparing.
Thank you. Thank you, Reggie.
Thank you.
Thank you.
Thank you.
Bye for now. Thank you. Bye.
Thank you, Robert.
Thank you.
Thank you.
Bye-bye. Bye-bye.